Hey there, this is Heather Van Wild with Raindrop Works. Trying to just do a quick update here. The gimbal is acting up just a little bit on me, so yeah, we'll try to keep this quick. So just had a short notice release hearing. Technically, it got classified as a bail reduction hearing at the long and short of it. The short answer, nothing has changed for defendant Alan Swinney, who has been accused of a number of crimes, including violent crimes, related to Blue Lives Matter or Back to Blue protests that took place down here at the Justice Center where I am right now, back in August 15th and 22nd of last year. Alright, like I said, the camera is not quite playing nice with me today. Anyway, like I said last night when I went over the motions that I found on the record, there were two different motions that are going on. One was resolved today, the other one was not. The request for bail reduction to a paltry $25 was denied. The motion to dismiss has not been heard yet. We haven't heard anything from the DA's office as far as a response or anything yet at this time, so we'll be keeping an eye out on that case. That being said, it appears, and this is a section that I have not gotten a chance to do much documentation or research on, that there are changes to the Measure 11 laws going into effect next year that apparently could have broad-reaching implications for preventative detention and bail amounts in general. I'm not sure what those changes are or how they're going to impact cases going forward. But Mr. Westover, the defense attorney for Alan Swinney, apparently has had this as a high focus of his cases, working on changing the old laws in regards to how bail is being addressed. That being said, after everything was said and done, the judge ultimately said that the questions that he is bringing up, that he's trying to get changes made to, would be better addressed by the appeals court in Oregon. Bench judges at the county level don't usually like to make case law. They're only the first step in the court process, and they usually prefer to let the appeals courts be the ones to make these binding precedents, especially when it's going counter to something that's been on the books for quite some time. So there was a lot of back and forth. In fact, Deputy District Attorney Vasquez said that we were going around in circles. And ultimately, the claim that started this went back to my reporting from the May release hearing, where Deputy DA Vasquez made assertions that they wanted to see Alan Swinney stay in jail because of the threat that he posed to the community. And if there was a bail reduction, they were going to attempt to file for revocation of bail to keep him in with no bail. At that hearing, the judge at the time, who happened to be the same judge that presided over this hearing today, declined to reduce bail, and at the same time, while it wasn't mentioned today, the DA's office had asked to increase bail to $1 million, which would have almost doubled the current amount of bail. That order was also denied. What caused today's hearing was the allegations that because DA Vasquez wanted to, or made noises about wanting to have bail revoked, that all of a sudden meant that they had a duty to make a filing to ask to revoke bail, and they never did, and it's been 3 months, which brought up a potential question of, was the bail set improperly, as in, did the DA think that Mr. Swinney is such a risk to the community that he could not be let out safely under any circumstances? Or were they content to just let things sit because they knew that it was incredibly unlikely that he was going to be able to raise the money for bail? DA Vasquez refused to say on the record whether or not he made statements. I can say myself that I remember comments were made about a revocation of bail motion, but I don't remember the exact wording that was used at the time. At the end of the day, it was pointed out that the DA is not the one who sets the bail. The judge does. And this has been before 3 different judges now, when at 4 different release hearings, and every time they have said that the same amount of bail is sufficient. The DA also pointed out that in previous release opposition motions, they have put out their concerns about Mr. Swinney being able to safely be out in the public if he made bail. And they do bring mention to the acts that he's been alleged of committing, his online statements, his statements that have been recorded on jail phone calls where he said that in relation to restrictions that Judge Silver put on him if he made bail, that he did not agree with them, that basically the only thing he would agree with is to stay out of Portland, which was the bare minimum of the restrictions that Judge Silver was putting on him. And all of this was noted by the judge today, but she did not seem particularly impressed by the idea that the failure to file a motion asking for a revocation of bail was sufficient to say that it was a change in circumstances. And again, the judge pointed out that this could be a question for an appeals court, but honestly, given how close we are to potential trial dates, I don't see that happening in this case. An appeal at this late stage, I think, would either be tossed out as moot because by the time it would get to an appeals court, the trial would have already happened and he'd either be acquitted or convicted, at which point he'd either be in jail without a bail anyway or released. So yeah, there is definitely questions going forward about constitutionality of bail and the processes that the DA's office is working with when dealing with bail and threats to the public. But it seems this case here is not the case where that's going to be decided. There is still a outstanding motion that was filed last week where Mr. Swinney's defense attorney, Mr. Westover, is trying to get the entire case dismissed without prejudice because of allegations that the grand jury was given improper instructions about how to treat events that happened on August 15th and August 22nd. Now, we have not at this time seen any response from the DA's office defending whatever happened during the grand jury. No hearing has been scheduled or anything. If this motion goes through, and if it does have the weight of law and evidence behind it, we could see a situation where Mr. Swinney would go free, possibly for a short time, while the DA's office would have to go through a new grand jury process with better instructions to allow them to get a new indictment. But That's, there's a lot of circumstantial things that we just do not know at this point. And I'm sure if I try to talk to the DA's office, I'll get a no comment because they historically do not comment on pending criminal cases. So again, long story short, Mr. Swinney is staying in jail at this time. I have confirmed with court staff that while there seems to be suggestions of a trial on or around September 20th, nothing has been confirmed. There are a few status calls that are happening on September 8th and 17th where they're going to try to confirm things. But with this outstanding motion about the dismissal, that could actually cause a delay on the trial itself if they have to resolve these pretrial motions first. We'll be keeping an eye on the case, and as we know more, we'll definitely keep you updated. If you're able to support us, feel free to, down in the description, I should have links to Cash App and Venmo and such. We do have a Discord server. I'm going to try to get a link to that in the description as well. And in the meantime, I'm going to go ahead and start getting this uploaded, make my way home, and we'll see you later. Peace.